Call on the Honourable Adam Searle.
Thank you, Mr Chair. I move opposition amendment number 1 on sheet C2017-063D. Opposition amendment 1, which I move, would have the effect of regularising the scheme proposed by this bill. This bill proposes that there should be these local planning panels in Greater Sydney and Wollongong, but not in Newcastle or Port Macquarie, where there's Port Stephens, where there has been a controversial council, not on the far north coast, where Tweed Council has been sacked at least once and a general manager removed from office on another occasion. And there are many other examples where you could see where the issues which are said to give rise to the need for this legislation in the first place apply in the bush as much as in Greater Sydney. I don't see why the government wants to let the National Party and its territory off the hook. We think if this is such a great set of measures to combat corruption in local government decision-making over major development proposals, then it should be across the state. And so that's why we move opposition amendment number 1. And I would invite members of this House to join with us to say, you know, we're not picking and choosing, we're creating a planning system for the whole state. And if that's the case, then the whole state should be subject to the one regime. And I know the argument may be that, well, in some places there are voluntary planning panels, but the planning panels proposed in this bill are of a somewhat different character to the ones that are voluntarily applying in some council areas. The most obvious difference being that in this bill there is no going back from a decision of these planning panels. The planning panel is the consent authority. Now where councils voluntarily have, I think, what are called IHAPs, independent hearing and assessment panels, councils ultimately still can overturn those and make their own decision, perhaps unwisely, but nevertheless they have that reserve capacity. They will not under this legislation, and so that's why we think there should be a unitary system for the whole state. I won't take up any more of your time. That's our thing.
Amendment number 2, Mr Searle.
Thank you, Mr Chair. I seek leave to move opposition amendments number 2 and number 6 in globo, as they both relate to the same subject matter.
Is leave granted? Leave is granted.
Thank you, Mr Chair, and I move opposition amendments 2 and 6 as by leave permitted to be moved in globo on sheet C2017-063 capital D. The purpose of these amendments is to prevent persons who are property developers or real estate agents from being appointed to and participating in the deliberations of local planning panels. Labor has long campaigned to rid local government of developers and real estate agents. We don't think they should take part in local government. They shouldn't be elected to councils, and they should not exercise the influence over decision making in that sphere that they have in New South Wales. And we will continue to fight on that terrain to clean up local government in this state. But if there are to be new local planning panels, and if the stated aim of taking this step is to improve the quality of decision making and to reduce risks and opportunities for corruption, we should tackle this issue head on and make sure that in this new scheme there is no place for property developers or real estate agents in a decision-making role. Now, people who fulfil those functions have important roles to play in our community and in the economic development of localities. But that is their role, to propose developments and to undertake those proposals, the risks associated with them, and to provide economic opportunities for those communities. But it should not be their role to play a role in the decision-making on those matters or to carry influence in the decision-making process. And so we should, as we embark on this new scheme, if it's to be enacted, by saying clearly there is no place for property developers and real estate agents in a decision-making role. The additional thing, which these amendments do, would also prevent councillors from sitting on these local planning panels. Now, the legislation already says that a councillor for one council area cannot participate on the panel for that area. But there is nothing preventing councillors sitting on local planning panels for neighbouring councils. And you might say, well, who cares? Well, one of the things we have seen in local government, particularly where the party loyalties have been weakened or not required, where you see people working together across party and fractional boundaries, but not in the public interest, where there is vote trading, you scratch my back and I'll scratch your mate's back, and the like. And we don't think that's appropriate and should be stamped out ruthlessly. But again, if we're going to create this new scheme of approvals, there must be no place for that kind of collusion and vote trading, and for that reason we don't think councillors should be able to sit on local planning panels, not in their own area, but not in other areas as well. Now, I understand that councillors, particularly ones who have been in office for a while and have developed, no doubt, lots of expertise and many useful skills. And on one view you could say, well, it might be useful to deploy those skills in this process. Well, it may, but it's not necessary. Because if it was necessary, we'd be leaving it to local councils. And if you're taking it out of the local council's hands, then you don't need a local councillor, even for another area, sitting on this decision-making body. And as I said, there is that ongoing corruption risk of councillor from Council A being put on the panel for Council B and vice versa, and all helping each other and each other's friends out behind closed doors. That must not be allowed to happen. And so that is why we have crafted and moved these two amendments to try and rid local council decision-making, particularly over major property development proposals, to clean up the sphere and to say that as we embark on this new scheme, there is no place for this kind of corruption risk. So I'd urge all honourable members to join with the opposition and put a firm stamp against developers playing this role to close down the corruption risks as far as we can.
The Leader of the Opposition.
Thank you, Mr Chair. I move opposition amendment number 3. That deals with the situation where the local planning panels, as they're conceived of in the bill, have a scope of functions that are much wider than just the consent authority functions under Part 4, but also would enable them to exercise a wide range of other administrative and financial functions to do with Section 94 plans, infrastructure arrangements and other matters that really go to the heart of council finances and operations, which I think is far too broad. I think it would be appropriate to restrict the scope of the operation of the local planning panel as proposed by amendment number 3, and I would ask other members to join with us.
The noes have it. The Leader of the Opposition.
Thank you, Mr Chair. I seek leave to move opposition amendments numbers 4 and 10 in globo, as they both deal with amendments touching on ICAC.
Is leave granted?
Yes.
Leave is granted.
Thank you to the House, and as leave has been given, I move opposition amendments 4 and 10 in globo. I'll speak to them. They both touch on ICAC, and it's about improving the accountability of local planning panels and making sure that the measures that we have in place to identify and prevent corruption apply to this new body or series of bodies that we are creating. As to amendment number 4, there has been some debate about whether the definition of public official is sufficiently broad to encompass those persons who act as and on local planning panels. But as the status of those persons are not elected councillors and they're not employees of a department or agency, we were sufficiently concerned that they might be in a sort of a grey zone, and we would not want a situation where at some future point in time when there's an important investigation into allegations of corruption, for some miscreant to drag ICAC back through the court system and for us to find there is another technical flaw in the ICAC legislation. Mr Chair, members, we've all lived through that movie before. I don't believe any of us want to revisit it. No sequels. And so we propose amendment number 4 to put the matter far beyond doubt. As to amendment number 10, the bill as it was drafted provided the only sanction against local planning panels was that members could be removed by the Minister if they were the subject of an adverse report under section 74C of the ICAC legislation. Only 74C, as presently constructed, didn't include local planning panels. It included JRPPs and other bodies, but not this new body. So it was an omission in the drafting, and Amendment 10 cures that. Together, these amendments make sure that the state's anti-corruption body will have full superintendence and supervision of local planning panels, which I'm sure was the government's intention, and I'm sure is the intention of all of us in this chamber and the expectation of the community. Let's not let them down.
Have it. The Leader of the Opposition.
Thought you'd never ask. Mr Chair, I move opposition amendment number 5, dealing with the cost of panels. Mr Chair, when joint regional planning panels were created by the previous Labor government to sit over the top of councils in respect to certain matters, one of the controversies was who would foot the bill. Not only did councils have to find meeting rooms and provide them with secretarial and other support staff, and in fact the planning staff of councils did the assessments, councils were also stiffed for the bill for paying for the sessional fees of the meetings. And I understand that the same is likely to happen with local planning panels, that is the councils, because they are currently the consent authority, even though matters are being taken out of their hands into these new local planning panels. These new panels themselves will have to be paid for by someone. They're going to be composed of experts who don't come cheap, as well as other persons whose time would have to be paid for, to say nothing of all of the sort of logistical and other supports that need to be provided. And of course the question is who pays. My understanding is that it's expected that local councils would have to pay, either out of their own resources or possibly from the fees paid by proponents for development. And that might be fine when you're dealing with multi-million-dollar proposals, because of course one of the triggers for local planning panels to have jurisdiction is that the proposal is worth in excess of $5 million. And of course the fees for that are not inconsiderable and may well cover the costs of planning panels, local planning panels. But that's not the only trigger. There are multiple triggers, including where proposals are being made by spouses or relatives of state or federal MPs or of councillors, past and present, or relatives of council staff. All of these are triggers that will lead matters to go to local planning panels and out of the hands of councillors. Another trigger will be that a proposal has more than 10 objectives. Well, that means pretty much most carports, every childcare centre, every second story on any house. There are so many where it is quite likely that matters that are not really in our mind as fitting within the new jurisdiction of local planning panels will actually result in these matters going to the local planning panel. And of course the development fees from them will not be in the multi-millions of dollars. They'll be in very small denominations indeed and won't cover the costs. So we don't want to see local councils ruined by this proposed new scheme, and we think the Department of Planning is the appropriate place to find the resources. Happy for the government to give us assurances that resources will be provided otherwise, but if not, we invite honourable members to join with us and pass amendment number 5.
The Leader of the Opposition.
Thank you, Mr Chair. I move opposition amendment number 7. Opposition amendment number 7 deals with openness and transparency. Where IHAPs currently operate on a voluntary basis, feedback I've received from local councillors and local communities is that there is much greater acceptance and integrity of outcomes and acceptance of outcomes where the planning panel operates openly in the view of the public, is open to public meetings, and when the public knows where and when it will meet and what it will be doing. And given that it is a consent, the scheme of planning panels conceived of in this bill is to replace councils as consent authority for many important matters, much more wider scope of matters than we would have preferred, we think this is appropriate. And one of the concerns that we've been hearing from communities and councils and other stakeholders in respect to the bill as originally conceived of by the government was the fear that these new panels would operate in secret, out of the public view, with people not knowing what was going on inside them. And there was a lot of fear and mistrust that this would lead to collusion and cosy deals and outcomes that are not in the public interest. And so we propose amendment number 7 to make sure that such fears or concerns are unfounded, and that just as a council does, these new planning panels should operate in the full glare of sunlight, with their deliberations open, seen and recorded. And that's very important. Just as a council has to be seen and recorded and for people to see what they're doing while they're doing it, so too these panels should have the same standards of openness and accountability, perhaps even higher, because this is an innovation in development approvals and in other decision-making areas. And it would be a bad thing and not in the public interest if these panels were even to be left with the possibility of operating in secret or in the shadows. And so we would urge all honourable members to join with us in adopting these measures designed to improve openness and transparency in the new scheme.
The Leader of the Opposition.
Indeed. Mr Chair, I seek leave to move opposition amendments numbers 8 and 9 in globo.
Is leave granted?
Yes.
Yep. Leave is granted.
Thank you. I move opposition amendments 8 and 9. These deal with the pecuniary interests of local planning panel members. In the bill, as it currently stands, where there is a pecuniary interest or a conflict of interest of a panel member, they're supposed to identify and disclose it. The bill currently enables the balance of the panel to, as it were, excuse them and to allow them to continue in the deliberation and decision-making process, or for the minister to excuse them and allow them to continue in the decision-making role. And it's not entirely dissimilar to provisions in the Local Government Act relating to councillors. However, councillors are elected. They come from local communities. They're embedded in local communities. They live cheek by jowl in the same villages and streets as the people they serve. Their children go to the same schools. They shop in the same shops. They are subject to a range of formal and informal accountabilities by being part and parcel of those communities. This will not apply to most of, if not all of, the local planning panel members. And so we say, if you're going to go down this road, if you're going to take these roles and functions off local councils, if you're going to create these new bodies to not only make development decisions but other important decisions, let's go the extra step and make sure that where these interests arise, they are not excused, and that those persons who are affected by those interests do not participate in the panel process. This will give more public confidence in the outcomes of deliberations of these new bodies.